There we go. Recording. Perfect. Okay, good. So welcome, ladies, to Business Acquisition Week 1. I just welcome you to our first ever, my first ever, they call it legal coaching session. As I said, you can find me on LinkedIn or my email, Jacinta, that may be useful for you. But I'm going to go a bit into background. What I'll do is I'll put you both on mute, but if you can chat, you can still use the chat button. Let's see if we can do that. Okay, perfect. So my background is as a corporate lawyer. I started work in the city, and as it relates to business acquisitions, because I think I want to keep it as short as possible and not make it about me, make it about the questions today. But just to let you know what my background is with acquisitions, we used to list companies on the alternative investment market, which is the stock exchange here, under the London Stock Exchange. And then what we would do is these companies would have letters of intent with lots of different companies, and then they would raise money on the stock exchange from investors, and then purchase these companies off the back of the investment that they had raised. And that was how I started life as a lawyer. Obviously, that's my background. I then went on to, I guess even in the last 2 years, I've probably done 10 or so acquisitions just on with small businesses. And this seems to be something that, I mean, I've seen the M&A, and I've probably had 5 deals come to me just in the last 2 months of people wanting to buy up companies. And so for me, the reason that I put this one as a kind of top of the agenda was because there seems to be so much M&A, mergers, acquisition work that seems to be coming through. And I've been working with a guy called Guy Bartlett, who helps companies to buy other companies. And I feel like this is something that's really expanding. So I thought, let me run this legal coaching and support companies that want to grow in this way. Obviously, I'm the founder of NaviStar Legal. That's my company, and we set it up to provide in-house legal support to small and medium-sized businesses or owner-managed businesses. And the reason that I wanted to run this legal coaching is not to sell anything to anybody, which is usually where you have a webinar and it's like, okay, and now here's the thing. Actually, it's to gain from people that are in the field, whether they be coaches, consultants, mentors, FDs, SMEs and clients of ours, gain from them an understanding of the questions that really come up for them, and give them an opportunity, give you guys an opportunity to get your questions answered, but also be in a group that you can get lots of questions answered over a period of time. So either you can help yourself to do the growing, or you can help the clients that you're working with that may be growing themselves. I call that affordable wisdom. It helps you because you get the information, but it helps me as well because I get to transcribe it. I get to know the questions that are coming up, and I can start putting this information into our content to the degree that it's not confidential, of course. If you've got any additional questions, we may have time at the end, so feel free to write them down, and then I'll unmute everybody and we can have some final questions at the end. We've done an introduction. So we're going to start with letters of intent, because Christine, I know that this was your question related to this. Letters of intent or heads of terms. Now, the reason that I've asked this question, what are they for, is because it leads on to the next question. Letters of intent are there to be a non-binding commercial document. They are there to allow both parties to get to an element of understanding, whether this be for business acquisition or anything else, by the way, because as we go through the weeks, there'll be other things that you have letters of intent for. But these letters of intent are usually non-binding, but they at least allow both parties to come together and say, yes, I want to pay this for what you're selling, and ask and get a bit deeper down into just a handshake. It's one step further along than a handshake. A letter of intent is useful, or heads of terms as they may be called, can be as short or as long as you like, but they are usually non-binding, except for certain clauses, which we'll talk about in the next question. And the reason that we use letters of intent is because what you want to do is get an agreement in principle before you start spending money. That sounds like an obvious thing, but you want to at least know that you're kind of on par, and you're both on the same page before you move forward. So that's what letters of intent are usually used for. Heads of terms and letters of intent are used interchangeably. Heads of terms tend to be in a more contractual-like form, and letters of intent tend to look more like a letter, but really they are the same thing. Yes, so that's just to give a bit of context. Why would we have a letter of intent before an acquisition? Because to draft all of the documents for a business acquisition could be costly, and therefore you want to make sure you're paying the right, the valuation, the structure, the skeleton of what the parties are agreeing to before you move forward. That might be a basic statement, but I think it helps us then to answer the next question, which is, what is the legal minimum required in the heads of terms? Now, I've stripped back, I looked to a letter of intent, and I'd be happy to share a version with you if that's useful. I'll put that on as a question to ask you guys later, but the legal minimum, in theory, if we go back to what the heads of terms or the letter of intent is for, it is there to be for both parties to get to the point where they understand what they are looking to agree to. So you would want the parties in there. Who's going to buy what from whom? Does it need to be the exact legal party? No, not at this stage. It might be, Christine and I have a relationship, and I say, Christine, I'd like to buy your company, and she's got 50 different companies. We may go into the depth of that later on, but ideally we know what company we're looking at, because we'll want to agree the commercial terms. In order to know what you're paying for, you want to know what you're buying. So even if you don't have the specifics of what you're buying, exactly what that looks like, you'll probably know it's company 1 and company 2, and I'm going to buy it for X. Sometimes it's picking a number out of the air. The FDs will know this more than me. Sometimes it's a matter of saying, look, I'm willing to pay you X. Sometimes it's a matter of working through a mechanism and knowing exactly, and frankly negotiating with the buyer or with the seller, between the buyer and the seller, about what they want, what they are willing to pay and what they're willing to receive. But essentially, you want basic commercial terms, the parties, a signature block. You want somebody to have signed it, even though you want to know what you're buying. And again, of course, I will share these slides with you later. But one important aspect of a letter of intent or a heads of terms, which you won't get in a normal document, is that we were literally saying none of these terms are binding. We'll come to that in the next question, but we are saying in heads of terms, they're not binding. Either party can walk away, and all this is doing is drawing a line in the sand to say that we both want to come together to start the discussions in a bit more depth. Now, the next bit is certain clauses must be binding. And this is the critical bit within the letter of intent that often gets missed out. It also, by the way, just for an agreement, we want to make sure that it says that the law and the governing law and jurisdiction is England and Wales. Why? Well, if it's in England and both parties are in England, probably not so much of an issue, because you're only ever going to go to the English courts. But what you wouldn't want if this was an international transaction is it for it to be governed by, or you having to go to Singapore to enforce your letter of intent. Now we come back to what's enforceable and what's not. Nothing is binding except confidentiality, i.e. both parties were going to keep the terms of this agreement confidential Usually it says confidential to the parties and to their advisors, and they won't tell anybody else about the terms of the agreement. Now that should include other people who might want to be involved in the transaction and who may want to purchase it. Governing law, we talked about. And then costs, and actually one thing that should be on here is exclusivity. Costs and exclusivity, I've said that's not essential. This is the question of what's the legal minimum required in the heads of terms. And I really have kept it down to the minimum, but we'll talk about exclusivity in a minute. But costs. If one party backs out and you have gone and spent the time getting yourself prepared, so letter of intent, you're then going to start putting together all the documents for the shareholders agreement, etc., then the concern for anybody is going to be that you're spending money, but that person can back out. So you will want something in there that says, except for costs, nothing else is binding. And you'll want that to be exclusive as well. Now, again, it's not a legal minimum. So just going by the question, it's not a legal minimum, but it's something that I would include in there. So I've added other useful clauses. These are not things that have to be in there, but they're things I would suggest would be in there. So is there anything that the two parties have discussed that are really important to the parties? For example, Christine's going to step away as CEO and Joe's going to replace her. That's critical to this particular transaction. Who's going to be a director? Who's going to be resigning? Is there any particular mechanism that you guys have talked about, and any assumptions that you have worked through that you say, actually, this is really important that we're looking. As long as these finances are correct, and as long as we're basing our valuation on these finances, then we will continue. So there are certain assumptions and conditions. It might be, for example, that you say conditional on the finances for this year being filed on time, or conditional. It may be January and the end of year was December. Conditional on the finances for 2018 showing the same as 2017, then we'll make a purchase. So these are sorts of things that commercially you guys will be able to think through what's important. Are there any deferred payment, or how are they going to be paid? That's important. I mean, it's important as a commercial term, but going a little bit deeper into payment, that is useful. The level of detail you can get is really useful. Is it going to be a share purchase or asset purchase, or is it going to be an investment? Now, actually, that's kind of what are you buying. So I think that's more essential. What is actually going to occur? But sometimes you can get it with saying, well, look, we know that we want to buy something. What this looks like and the structure of this, we don't know. So defining what the structure looks like. Exclusivity and time limits. Now, if I am going to buy another company, and the same is true kind of in the opposite way around, if I'm going to buy a company, I want to make sure that I am the person who has exclusive rights to buy that company. At least for 3 months, if not 6. 3 is usual, 6 is a little more than expected. And you would give time limits for people to, on the other side, if I'm having my company bought, I want to make sure that I've got a time limit on which I can start speaking to other purchasers. So exclusivity and time limits are really important. If during that time of exclusivity, either party decides to walk away, then usually that's when costs start being paid by the other side. We usually say something along the lines of warranties and indemnities will be standard. Or if there are specific issues that we know about already, I don't think we'll get to warranties and indemnities today, but if there's specific issues, I would put those into the letter of intent. And who are the costs? Yeah, costs, how are they going to be paid, by who, when, and if you are the person that's purchasing, that you are not responsible for any losses as a result of anything that you are doing. Limitation of liability is a really important one to get in. Like I say, it's not a legal minimum, but I would include to say, this isn't a joint venture. This isn't a partnership. We're not responsible for any of your losses. We are responsible for legal costs, maybe, if we back out, for no reason, then we're responsible for costs. One of the things I see around this, just to delve a bit deeper into costs, it would be kind of conditionality around costs. If I back out of the deal, it's too simple. If I back out of the deal, then I will pay your legal costs is a little bit too simple. Because if I back out of the deal, but it's as a result of the company not being what I thought it was at the point at which I signed up to the letter of intent, then I shouldn't have to pay. Working those nuances out takes a little bit of time. If you're ironing it out, it takes a bit of time to work out when those costs should be paid. And the way that we've done it recently, we've had one which was quite heavily negotiated and one which they just went, yeah, no problem. It was, if there's a materiality, using the word, if there's a material change, and material change usually gets you around it, but some lawyers don't like materiality, and there's a lot that you can read into the word materiality. So ultimately, you're going to end up having a bit of a bun fight about costs if one party backs out anyway. How committed are you to the letter of intent when signed? Oh, I think somebody's just about to join us. Oh, chat. Yes. Okay. So materiality is similar to best endeavors. Exactly. It's one of those phrases that is contested right up to court, and we don't want to be engaging with that. But equally, if you want to get a letter of intent across the line, knowing that this is the only clause that matters, and you're both working with good faith, you usually take a risk. I'm actually going to talk a little bit about risk, partly because it comes into a bit of philosophy in the way that I think about things. So how committed are you to letters of intent when signed? What can you change afterwards? In theory, everything. Letters of intent are not binding. In theory, you can change everything, except that. If you think about it, when you're signing up to a letter of intent, you're doing so in good faith. If you're offering costs, which we've talked about before, you're actually saying, if I back out or if I change the deal materially, then I'll pay your costs. So how much you commit to this depends on what you're willing to accept from the other party, because you don't want them to back out. So for me, letters of intent are non-binding, therefore you can change it at any point, and usually they do change. Commercial terms don't usually change, except that you're saying, look, I am going to pay 90 million for this company, except that there's 45 million pounds worth of liability, which we didn't know about. So therefore, I'm now going to pay 45 million. So if it's fair and reasonable to make adjustments, but it's not necessarily, well, let's say this. I know a lot of people that go into a letter of intent, get a letter of intent on the table, and then their only intention is to roll with the exclusivity and force that person to basically come down at a lower rate. And of course, that's business in a lot of ways. But my concern with doing that is you lose good faith and goodwill with that other person. So if your intention is to go in and be fair and be committed to, you're saying what you mean to say, everything else based on that relationship. There is no other, well, actually, I was going to say, there's no other relationship except when you're buying someone else's company that probably will last as long, because you're often the person you're buying the company from, you're keeping them on as support. So you will want to make sure that you've got a good relationship going forward. And if they think that you're going to be sneaky or conniving, that's a different thing. However, making sure that you've got a good commercial deal and making sure that it all stacks up, that's absolutely fine to make changes. As long as you can back up the change, it's fine. In theory, it's non-binding, except for the exclusivity. So yeah, in theory, you can change whatever you like. Okay. Okay, so we'll come on to the longer question, which is, I'm discussing an informal arrangement with a contact who has a small business with about 4 to 5 clients. She wants to retire in 2 years' time. We're exploring how she can join our business for the next 2 years. We can support her clients during that period with a view to eventually taking over the contracts when she retires. She does not have any formal contracts with her clients at present, but they are informal rolling contracts. And the question was, what pitfalls do I need to look out for? And what do I need to consider in terms of a contract between our two companies? Now, this to me is, it's not necessarily a share purchase. One thing that I didn't mention earlier, which I think will be useful here, is you can purchase the shares of a company. I know you know this, Christine, but I'll remind us of the principle. So you can either purchase, if I have a bucket or a ball, and within that are all the things that I'm going to purchase, I purchase the ball itself, i.e. the shares of the company, then I'm purchasing everything within that company. That includes debt, that includes assets, that includes people, and we'll come to Chupi in a minute, that includes employees. And so if I'm purchasing the shares of that company or a major part of the shares of the company, then you're literally buying everything. What we can do is sometimes cherry pick the bits that we want within the company. For example, we may not want their brand, we might just want their contracts. And this kind of comes within that. The question, though, that I would ask is actually, are you purchasing a business, which is an entity of going concern? You may not be purchasing the shares of that company, but you're purchasing the business aspect of the company, which is, you've got the ball here. It's a big portion of that ball. It may be that you don't use her brand. It may be that you don't use her company name, but you're basically purchasing a business. And there are different, just to kind of draw a line under that conversation, there are different tax, liability, due diligence considerations for buying assets, buying a business, and buying shares. Just different things that need to be thought about. I'm going to assume that this is buying a business, and I'll answer it as such. So, pitfalls. First thing is, I need to know more about the situation, but I think we're going to manage a little bit of that later. Question, would you be buying a business of a going concern or just the contracts? Would you be buying them, or would you be being gifted them? I.e., this woman is going to be working for 2 years on these contracts, and just gently they're going to be passed over to you? Or is it going to be that they transfer over to your company today and that she continues as a consultant? So there's quite a few questions that I would ask around that. What is your end goal? And I think when we were talking earlier, it's like growth. Growth is the focus, really. Some of the considerations for you to think about will be liability, tax, complexity, the level of control you have over the company, or level of control you have over the contracts, and the time it will take for you to make that transfer. I probably will discuss that as I'm going through my thought process. Will she get an ongoing payment? My biggest concern, and I think it's a commercial one, not a legal one, but an important practical consideration is, do those clients only want to work with her? How is that client communication going to be managed? Because for me, I would rather make that transfer sooner rather than later and manage the relationship in much more of a parallel way so that those contracts are transferred earlier. Yes, so I said transfer when. My thought process is you transfer it earlier. Now, the documentation that you would need in order for this to work depends on which way you transfer it. I'll give you some examples. If you're going to be going to the client, there's no contract in place at the moment. If you're going to the client and saying, "Hey guys, we're going to be working," let's call her Jane. We're going to be working with Jane going forward to put these contracts together. We'd like to work with you. Jane's going to continue to work on these, on your contract, but we will transfer the invoicing over to you today or next week or next month or in 3 months' time. And the only thing that's going to change is the invoicing, and we'll start putting some sort of contract together. Now, that in theory means that they are your contract, they are your client from day one or month three, where somewhere within those first 3 months. And Jane can continue working on those contracts. She gets paid. I mean, I don't know whether you're going to pay her as a profit share or she's just going to get all of the money from those clients for those first 2 years, or whether she's on some sort of consultancy agreement. The thing with that is your company will take the liability for anything that goes wrong. Obviously, you're going to be taxed. The money will be coming through to you, so you'll be paying tax. It's a very simple way of doing it. It gives you total control over the clients and the contracts, which are, I mean, even if you don't have a contract in place, we then go back to liability, by the way. You may have control over the contracts, but you don't actually know what the contracts look like. And because you're in control of them and you're liable for them, this is the time in which you might want to think, let's put something in writing just so that we are clear on what we're providing to these clients. But my gut feel is, because of the nature of what's being done, it's kind of project-based. That's an assumption, but I'm assuming that there's work coming in from them, and they say, hey, can you do this particular piece of work? And she says, yes, I can. And then that, you know, each time that new piece of work is agreed. But that's an assumption I'll make. I'll check that with you later. And in terms of the time of transfer, you'd be doing it earlier. My biggest concern would be that she would change her mind or she'd make a different decision. So if you want to make that transfer now, or you can make that transfer in 2 years' time. So you would have probably a letter of intent or a heads of terms, or you would have a contract. I guess I'd call it a joint venture agreement. Joint venture agreement not really being a term, but I'd have a partnership agreement with her that would set out, look, over the course of the next 2 years, this is how we're going to work. You're going to help transfer this over. This is the work and the support that you're going to provide. And in 2 years' time, the process that I was talking to you about, that I suggest happens now, that will, you know, that transfer will happen. So really, the two ways of doing this just come down to timing, whether you do that transfer now or whether you do that transfer later. If you do the transfer now, you may get the benefit of kind of building up a contractual relationship with the clients, but actually without the liability. And Jane remains responsible for that. And she remains for getting paid, and she remains responsible for administration. But if you go down that route now, you start having the liability for those contracts, even though they're not in place. So I think if you're going to take responsibility for it, and if you're going to be in control of it, if you're going to do it sooner rather than later, you want to make sure that each of those clients has something. It doesn't have to be a full contract. It can be an email or details, some sort of process that just allows you to know that you're protected. At least it's got limitation and liability. At least it would have payment clauses so that it's very clear. And what else? Payment, limitation, liability, and I'm missing one. I'm sure it will come to me later. So hopefully that kind of answers your question in a bit more generic way. I know we're going to go, we'll come off a little bit earlier, in fact, in a few minutes, just to get a bit more information. So what due diligence requirements are recommended as a de minimis? I've written 7 questions, and they are really short questions. I have a full due diligence questionnaire that you can crib if you want it. That's all right, that due diligence questionnaire. I'm happy to share an example with you, but these are the 7 core areas. Oh, actually, I'm going to go straight. So financial, commercial, financial phase 1. Let me have a look at the finances. How do I know what I'm prepared to pay? Finance phase 2. That's when they start giving you the more in-depth. You probably get access to 0. I would only, after finance phase 2, start to do commercial and legal due diligence, because commercial and legal often costs a lot more. And here are the 7 questions. So 1, do they have company records and are they up to date? I can tell you the answer will probably be, no, we don't, and no, they're not. But it's worth asking. And if they are particularly organised, that's good to know, because it means that they're going to be organised going forward. Question 2, what are your key or material corporate and commercial contracts? Now, I've put a little slide in here which says some of the questions to ask around these. We probably won't cover them, but essentially key or material corporate and commercial contracts, top 10, top 20, depending on the sizes. Who are your key employees and personnel? What terms are they on? Holiday, pay, sick pay, benefits, etc. Personally, I have a spreadsheet that literally asks them to fill in all of the information, and just basic stuff. I mean, they should be able to download that from their own records. Intellectual property rights, have they been registered? Are there any outstanding disputes or threats of litigation? Big one. And I would make sure that it's anything that has been notified to them, not just disputes that are in the courts, because you want to be aware of any big issues that may come up. Are you registered for data protection? Well, this is just, especially if they're dealing with consumers, this one's going to be one of the ones that I think, particularly with GDPR, seems to come up most often. And then, is there anything else that I should know about this company? Is there anything else? Anything else that if you were buying this company, you would want to know is a great question to ask. Now, I have a list of 100 questions that you can send them, but those 7 questions should get you to the nub of, within an hour, should get you to the nub of anything that might give you concern. Here's the focus on material agreements, which is value and length. Focus on which ones are material in that agreement. And then I've got a little bit about how do you mitigate some of the material, because it doesn't matter if a material agreement is a problem, or if anything comes up as a problem during the due diligence. What's important is that you're able to mitigate it. So you can have a look at that later. Cheapy, I've answered why is it a problem. Cheapy is there to safeguard employees if a major contract or a business, in this case, is transferred between suppliers. So just on the last question, if it's just the contracts that are being transferred, great. But if there are other employees as part of that business, those employees would have to come over. Now, it means that they come over on the same terms, and we can't, other than giving them more positive terms, we can't change their terms of employment. So that means holiday entitlement, continuous employment, etc., etc. Now, the next question will build on this, but if you do then change the terms of the contract, it's a breach of contract, and then there's a possibility of employment tribunal. Doesn't mean they will go to employment tribunal. It just means that there is a case to go to the employment tribunal. The question was, are there any ways to avoid cheapy transfers of staff you don't want? And really the answer is no, not really, because cheapy is there to protect and safeguard clients, employees, from this. The risk is then employment tribunal, fines and compensation, but it's not about avoiding, it is about adhering in the proper manner to employment law. So redundancy is usually the way that changes can be made. You can do that, and the way that I've seen it is twofold. Usually it is that the new employer can either change the terms of business, employee terms, or dismiss an employee through redundancy for economic, technical, and organisation reasons. But it can't be to do with the transfer itself. It can only be to do with those reasons. Now, I argue that's ridiculous, because organisational reasons are always going to be to do with the new transfer, but the new structuring of things. For example, I've seen teams in Manchester being merged with teams in Bristol and offering them, saying, hey guys, look, you're more than welcome, Manchester guys, to come to Bristol, but that's a material change, and that's where our team is going to be. So we would love for you to come, but that's a material change. And so there's been a redundancy process as a result of that. However, it's important to go through the redundancy. I suggest that we jump off now. I'll just tell you the next steps now. So the next steps will be, I'll send you this video. Next week, I'll send you the questions, and the questions before. You guys can send the questions for next week. I think before Monday next week, there'll be an email. and I'll send you this video so you get to see some of the questions that have been answered. My suggestion is we jump off, just quickly tie up some of those loose ends on one of those questions, and I'll stop the recording if that's okay. Let's see.